Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm your host, Laura DiFrancesco, founder of Dean Street Law. Since our inception in 2019, we've closed over $10 billion of transactions. We focus on lower middle market mergers and acquisitions. Prior to founding Dean Street Law, I worked in big law for 8 years, and I'm also the founder of 5 other businesses: Ethereal Farms, Flourish Co-working Space, White Horse Investment Group, Laura DiFrancesco LLC, Dean Street Law, and more. And then I also have an upcoming book, which I'm really excited about. It may already be out now by the time that you watch this. It's called Entrepreneurship Through Acquisition, a legal guide to buying a small business, all about the emerging world of ETA people are talking about, but know that it is a concept as early as the time of commerce. As soon as there was businesses, folks were buying and selling businesses, but now MBA programs are packaging it up in a new way to show that there's another path to entrepreneurship beyond just starting a business, which I love to do, but I also love to support folks buying a business. Here, we're actually going to be talking about post-closing legal support. So you're buying a business, you have gone through the process of buying a business, and you want to think of either ahead of buying the business or in the process of buying the business to see really what is the upcoming process once you get past closing. So first of all, from a business perspective, this is where the rubber meets the road. This is where you really dig in. And honestly, this is where the journey starts. You are an entrepreneur once you have a business to run. And from there, it's going to be learning, absorbing, getting your feet under you, getting to know the market, getting to know your team, getting to know your business and products, and really ingratiating yourself in the business. This is a really important time to absorb and observe. And unless it's a turnaround that needs drastic action taken immediately, I highly recommend that you take the first 60, 90, 120 days to learn the business and see how your ideas would flesh out. Start playing the ideas that you have through your head. Everyone, when you're buying a business, they have hopes, aspirations, ideas of what to take it to, how to take it to the next level, how to make it more profitable, increase your return on investment, and really make the juice worth the squeeze, right? But in order to make well-informed decisions, you have to give time for your ideas to gel, give time for you to be your own worst enemy and devil's advocate and argue with yourself about the pros and cons of each decision, because it's easy to have ideas. It's difficult to implement them successfully and to have a positive return on investment. That's what's important. A lot of folks can think about this more generally when they're thinking about buying a home and then doing full ideas of renovations before ever living in it. And then that's when people start to have regrets. I wish I had done that. I'd spent so much money on this. It would have been easier to do that. It would have been more efficient to do this. This would have had a better return on investment, right? In order for you to build confidence in your ideas, you should test them. So from a business perspective, I highly recommend, if you have the luxury of time, to give yourself the time to test your ideas, to get feedback. An idea from the top is only as good as its implementation at the bottom and all the way up. So if you have an idea, but you can't get anybody on board to adopt it, your change management will fail and the idea will fail. And thus the return on investment will be negative because you'll have made the investment and not gotten any return on it. So if not caused more distress or time or frustration or anger, people thinking, oh, well, this person's coming into the business thinking they know everything when they haven't been the person who is doing this on a daily basis. There may be a rhyme and a reason to the reason why things are being done the way they are. Obviously, there's always opportunities for growth and improvement. I love to tinker in my businesses every day to improve, but that doesn't mean that the way that things are being done currently isn't for a specific reason. And so it's oftentimes great to have conversations with employees, obviously the owner. This is going to be a really important time for knowledge transition and transition management. So first off, having your ideas, creating a space for them, absolutely. Have a post-closing business plan, but know that that is your ideas. It's your directions on printing out your MapQuest directions. But ultimately, if there's a blockage in the road, your MapQuest directions can't tell you where to go. They are a snapshot, a set of ideas, a set of instructions based on information at that time. And then you have to live and breathe with the company and assess that idea that you had earlier. So create a business plan. Absolutely. You're going to need it for your lender. You're going to need it for your investors. You're going to need it for your own peace of mind to confirm that you feel like you can be successful with this business. So yes, create a business plan, but then let it gel, let it mesh, let yourself be your own devil's advocate and question every decision, every thought, every idea. Give this your time to breathe, observe, learn, and really focus on transition management. So first 90 days, 120 days, transition management, getting up to speed on the business, transitioning knowledge, standard operating procedures from the seller parties to you, writing everything down, getting everything documented so that you're able to fully operate the business successfully yourself, and also use that time to have deeper conversations with employees. If you can, meet with every single employee and contractor if it's strategic and advisable, right? Some contractors, sellers or buyers may not want to meet with because they don't want to signal a big change. They want continuity to be the main focus. And so meet with employees and learn what they're doing and learn why they're doing it and the systems and processes they have, and ask questions. Be the person seeking knowledge rather than sharing answers, because ultimately, if you're not running the business and in the business every day, your answers may not be relevant and they may not actually support your end goal in the way that you think they will. So take that time. And then, like I said, also continuity and change management is really important. So from a continuity perspective, immediately employees are thinking, is my job at risk? Am I going to be laid off? Is this something that's negatively going to affect me? So employment agreements, letters to employees, continuity, that's a big part of what we're doing pre-closing to support you in your post-closing transition. This may include retention bonuses or some sort of employee plan where they can grow with the company, whether that's in bonuses or in other cases where I have a current client who's looking to transition the business to an employee-owned business. So there's lots of things in between. And these are things that you're going to want to be talking about with your attorney beforehand, because in order for us to structure the acquisition appropriately and the business correctly, we want to know your future ideas. It doesn't mean that you're necessarily going to implement them immediately, but we want to be able to set the stage and the foundation for where you want to take the business. And then ultimately, it's going to be like every entrepreneur, an everyday evolution where you're constantly evaluating your ideas, your risks, your mitigating factors, and how you can lead the business. So those are just a couple thoughts from the business perspective of how you want to consider your post-closing transition. Continuity should be a big component of your focus, as well as knowledge transition and transition management, making sure that ultimately the business can continue with its baseline success as its bare minimum. And then you think of growth on top of that. Obviously, these things take time, and it's good to take that time as an entrepreneur, you're constantly assessing opportunity, risk, and how you can mitigate that risk. And all of your ideas are opportunity with risk, and you have to think of how you can mitigate that risk. A lot of the times people focus so much on opportunity, they don't consider what other impacts those ideas may have. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. So transition planning and how you have the seller on board is ultimately going to be derived from your overall strategy. Sometimes you may buy a business and want the seller to stay in place for 3, 4, 5 years, assuming you're not doing an SBA loan, which makes the maximum that you can have the seller involved post-closing of 12 months. That is going to be a considerable focus, considerable impact is, are you doing SBA financing or are you not? And that can determine whether you have the seller engaged for a shorter period of time or longer period of time. Sometimes you'll hear people say, well, I want the seller out immediately because I don't want there to be confusion about control and influence and decision-making in the business. And sometimes that's certainly true. All depends on your strategy and your growth. Some folks are buying the business but don't want to be the day-to-day person there. So then you have to think, should it be the seller or should you be elevating an employee, or was the seller not involved in the day-to-day? So you don't need to make that change because there is already a management and executive structure in place. So the length of that seller involvement will depend heavily on your strategy and your ideas. And involvement, the key involvement of the seller is of course going to be knowledge and transition management, which will depend on how easy that transfer is. Are you already in the business and you're purchasing a competitor through a strategic acquisition? Then knowledge transfer may not be quite as important as someone stepping into an industry that they've never operated in. And are standard operating procedures written down? Are there metrics for success? How organized and documented is this business and its systems and operations? If it's super well documented, there may not be as much requirement. But if the seller is having all the conversations with the customers via phone, via his personal cell or something like that, his or her personal cell, then that may be requiring considerably more handoff of the relationships and everything. And then seller's involvement post-closing could be just transitioning, retiring, that's their desire, or they may want to help bring it to the next level, but take some chips off the board and have only a minority interest. So ultimately, it's going to be what the buyer and seller agreed to, and there are pros and cons for everything, all driven by strategy. For that transition planning, there's going to be some sort of legal document stating the engagement. If they're really truly only handing off the reins and they're minimally involved, it might be something as a provision in the purchase agreement, but most likely it's going to be some sort of independent contractor agreement if they're going to be a consultant or not an employee of the business, an employee agreement, or a transition agreement. Transition agreement is going to be specifically only if there's perhaps a license involved or something where they're providing transition services. But most of the time it would be an independent contractor or employment agreement that you'll have with the seller to outline their transition obligations. That's super important, especially when you're talking about companies that have licenses, electrical companies, plumbing companies. There's so many different types of companies that are licensed. And if there's someone who needs to be licensed, that's something you're going to want to be thinking about immediately pre-closing. Either as a buyer, do you want to obtain that license, or Are you going to have somebody else on the team who can have that license? And do you have backup if for some reason they leave? And then if you do need to use the seller's license, how are we legally going to structure that? Those are all important conversations that you'll have with your attorney. And if you'd like to speak with us about it at Dean Street Law, of course, we're happy to chat with you about that. With respect to the legal obligations post-closing, from the buyer's perspective, there's most likely going to be some little things, both on buy side and sell side, that are going to be continued to follow through from a transition perspective and a legal perspective post-closing. This might be consents that you might want to obtain or notices that you need to provide that weren't critical for closing or weren't required for closing. They may also be transition planning for employees, doing a retention bonus plan or employee ownership plan in the future, or evaluating contracts. It could also be renewing permits or other types of contracts. For instance, certain companies have bidding that they need to do for contracts on a regular basis. So from post-closing support, we in the due diligence report are tracking timelines, and wherever possible, we try to provide our buyers with an understanding of what permits are or what licenses are expiring or what contracts are expiring quickly, so that it doesn't become something that all of a sudden the buyer is getting a notice from a government organization that they are no longer operating in accordance with law and they're getting fined. We obviously don't want that to happen, so we include that as a proactive part of our due diligence wherever possible. And then we also want to communicate that to you. Sometimes there's also a little bit of post-closing cleanup from a legal documentation standpoint. For instance, if there's a transition of the entity structure, currently we're working on a post-closing conversion of the entity structure. Another instance is where you might have some contracts with the seller. This is rare, but you might have some contracts with the seller that the closing is so time sensitive that you get the big stuff done and then you leave some open items. Typically, it's going to be everything's agreed to, but there are some instances where that's the case. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including our template LOIs, letters of intent, pre- and post-LOI due diligence request list, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. All the links are in the show notes. And then there's also going to be post-closing obligations, right? Indemnities, escrow, employment agreements. So we put together a post-closing timeline for our clients that we deliver after closing, and that is going to set forth the different timelines. Sometimes there's insurance obligations post-closing that someone needs to provide, or an escrow that's going to wind down after a certain period of time. So you want to consider all of those timelines and just know where you're tracking. Time will move very quickly. Once you buy a business, you'll be in the thick of it. And so you want to be thinking about these, get them on the calendar, think in advance of what you need. And of course, from a post-closing legal support standpoint, we're happy to support with various aspects of the post-closing practices, whether you need to redo contracts, that would be quoted out separately with a separate legal service, or if, the post-closing timeline itself, that's part of our services that we provide so that you're planning and ready to go as soon as you're hitting the ground running and you've bought the business. Now, with respect to the thing that most people are nervous about with respect to post-closing is the potential for disputes and litigation. So there's a lot of risk mitigation that we can do within that. A lot of that is really doing the right work at the beginning during the transaction while we're assisting our clients in buying a business. So some folks want to just pay $5,000 for a purchase agreement, which will not legally transfer the business. and is a waste of money, both from buying the business and not actually having a business and owning a business that you think you do. And then also from the perspective of, well, you just wasted money on legal support that didn't do you anything. So there's this misconception that it takes so little legal work to buy a business. And that's incorrect, both from the fact that you legally cannot transfer the business with that single document, as well as to the fact that if you're looking to mitigate risk and the likelihood of litigation, the best thing to do is a practical one, which is to do your due diligence and work meticulously leading up to closing so that you're aware that the business that you think you're buying is the business that you are buying, right? The greatest likelihood for litigation is a disparity in understanding of what you think you're buying and what you are buying. And that's where the greatest risk comes, both from a business that cannot support its debt obligations post-closing, and you need to then file for bankruptcy, to a seller being honest and transparent and correctly disclosing, making the correct representations and warranties to avoid post-closing litigation. So no matter which side you're on, doing the work and actually engaging an M&A attorney who can guide you through the representations and warranties, indemnity obligations, due diligence, and properly completing it both from the buy side and the sell side is all super important to be able to mitigate risk. It is 10 times more expensive and costs 10 times as much to fix a mistake than to do something right from the beginning. Legal is the area where that is true more than anything else. A lot of folks think that when they're running a business or buying a business that legal is where they can skimp, legal is where they can save. If they're operating a business and managing a profit and loss statement, managing a balance sheet, they may not include a budget for legal. And that's a mistake. Whether you're founding a company or 20 years into operating a business, ultimately there is a certain amount of legal in business that is non-negotiable. That's why I became a lawyer, to be an entrepreneur, because it is the laws and the fabric within which we operate. It's the rules of the game that we play by. So if you want to disregard the rules and not do due diligence, then yes, your likelihood for post-closing litigation is very high, because the likelihood that you buy the company that you think you're buying is really low when you're not doing the proper work throughout the process. The best way to mitigate risk for post-closing litigation is, one, to work with someone you trust, who you believe is doing right by you. If you're getting bad vibes from the other party, that is your number one signal that this is not the business for you, because a contract is great. But guess what? It is only going to help you if you win in court and the contract does what you need it to do and they have money to make you whole. So relying on contracts to just make it come together, practically speaking, logically speaking, from a business standpoint, doesn't work. You have to first trust your gut, trust your intuition of the person you're doing business with. Then you lead by doing the work necessary to complete the transaction, due diligence, documentation, engaging legal advisors, and then you're able to rely on contracts to support you. With that said, the worst thing that you can do post-closing if there is an issue is just dive in and say, I'm suing you, you're responsible for this. The best thing that you can do is circle up with your attorney and say, hey, I'm having this issue. What do the contracts say? How can we address this? And then you don't want to just send a letter saying you're in breach of the contract. Have a conversation. Say, hey, this happened. I'd like to get in touch on it, and can we have a meeting? So we always include dispute resolution provisions because it's beneficial to everyone to just have a conversation for 30 or 60 days and to spend the time necessary to resolve that conflict, then to escalate it. Litigation is expensive, and it oftentimes doesn't get you what you think it will. You want to make sure that you're operating the business, that you're able to be successful, that you're able to meet your obligations when due, right? All of those things, cash flow is important. That's why from a practical standpoint, when we're thinking about documentation, we're thinking about indemnification and remedies, escrows, set off and clawback provisions, all of the different ways that you can legally recover in the event of an issue. we're thinking through what's your cash flow position? How will this hurt it? Are you able to make an informed decision? We know this litigation may cost $350,000. How will that impact your cash position? And do we need to create an escrow to account for it if it's going to negatively impact your cash position and make it so that you're unable to meet your debt obligations? We're thinking through that from a practical standpoint, because the worst thing that can happen post-closing is that there is an issue and you have to go through 3 years of litigation to get $1 back. And at that point, the business is in bankruptcy, right? We need for things to logically make sense, and your contracts are belts and suspenders to be able to support you in recovery. But ultimately, if there is an issue, first go to your attorney, talk through the issue, then work through a dispute resolution period where you're talking through the issue and the solutions. And then if needed, then you escalate. But litigation oftentimes won't get you what you want, especially not quickly. And when you're moving in business, you definitely have to move more quickly than litigation generally allows. So those are just a couple of things to think about when you're thinking about post-closing. There's running the business, there's post-closing legal support, and then there's mitigating post-closing risks, all of which can be done well with having the right legal counsel. If you'd like to speak with us, you're welcome to schedule a consultation call. But I hope that you tune into our episodes. Be sure to subscribe and leave us a 5-star review. If you'd like to share the podcast with friends or colleagues in the space, that would mean the world to us. And you can check out my upcoming book, Entrepreneurship Through Acquisition, A Legal Guide to Buying a Small Business. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal-making.